3, 2, 1, start. Learned additional sessions judge, seized of both the criminal appeal and criminal revision, proceeded to decide the same on 21/9/2013, and by means of common judgment, dismissed the criminal revision, filed by the complainant of the case seeking enhancement in their sentences awarded by the learned magistrate, section 30, however, in criminal appeal of the present petitioners, their sentences were somewhat modified and reduced, the present petitioners, feeling still aggrieved of their conviction and sentences, as was modified and reduced in appeal by a learned additional sessions judge, preferred the present criminal revision within the meaning of section 435/439 read with section 561A CRPC. The learned deputy prosecutor general representing the state, raised a preliminary objection as to the maintainability of the present criminal revision, on the ground that against the conviction announced by the learned magistrate, the present petitioners filed their appeal against such conviction before the learned additional sessions judge, whereas, a criminal revision was filed by the complainant seeking enhancement of sentence awarded to the petitioners by the learned magistrate, and the learned additional sessions judge, by exercising the appellate and revisional jurisdiction, both, decided the matter. And once a revisional power has been exercised by lower revisional court, the concept of a second revision in criminal law is not recognized, hence, the present petition, in his view, being second revision petition, would not be competent as provided in section 435 CRPC. In support of his arguments, the learned deputy prosecutor general has referred the cases of Pendagul and another versus the state and another 1987 SCMR 886, Muhammad Nawaz versus the state 1995 PCRLJ 35, and Muhammad Rizwan versus the state 2008 YLR 1395, with the contention that the concept of second revision is alien in criminal jurisdiction, In comparison whereof, the learned counsel for the petitioners has argued that the present criminal revision has been filed from the findings arrived at by the learned additional sessions judge, while exercising his appellate jurisdiction as envisaged under section 408 CRPC, and, thus, none else, but a revisional remedy is available to the present petitioners, After hearing the arguments of the learned counsel for the parties and going the case law on the subject as noted herein above, I am of the considered view that the consolidated judgment as was passed by the learned additional session judge, whereby, he not only decided the criminal appeal under section 408 CRPC, filed by the present petitioners oblique convicted persons, but also decided a revision petition, filed by the complainant of the case seeking enhancement, brings some confusion in the mind of the learned deputy prosecutor general to believe that, perhaps, the revisional jurisdiction by the lower revisional court was exercised even while deciding the appeal of the present petitioners oblique convicted persons, and, thus, the present petition is being termed as a second revision, In Pendagul's case supra, the Honorable Supreme Court of Pakistan has held that there is a bar on the power of High Court to exercise its revisional jurisdiction with respect to an order made by the session judge under section 439A CRPC full stop. The words with respect to an order clearly denotes to an order passed by the sessions court exercising its jurisdiction under section 439A CRPC full stop and closed.